Sheila, are we recording?
Yes, we are.
All right. Good morning, everyone, to the March 14th, 2024 meeting of the New Mexico Oil Conservation Commission. For the commissioners, this is the first time we've had the chance to use the new room setup. Would remind everyone, some of you have been in divisions hearing, are familiar with this. You have mics in front of you. Just click the button on the right when it lights up green. You speak, you'll be able to hear out into the crowd. And when you're done speaking, I'd ask that you turn off your microphone. And with that, I'll do a quick roll call. Commissioner Mpoma.
Present.
Commissioner Bloom.
Present.
Let the record reflect a quorum of the Oil Conservation Commission's here. First item on the agenda is approval of the agenda for today's meeting. Do we have any questions, comments, or additions?
No, Mr. Chair.
Can I get a motion to approve the agenda?
I so move.
I second.
Quick roll call vote. Dr. Mpoma.
Approved.
Commissioner Bloom.
Approve.
Let the record reflect that the agenda was approved unanimously. Next item on the agenda, approval of the meeting minutes from our last meeting, which was on January 11th, 2024. Those were circulated to the commissioners yesterday evening. Are there any comments or additions to the minutes?
No, Mr. Chair.
Can I get a motion?
I so move.
I second.
Dr. Mpoma, roll call vote.
Approved.
Commissioner Bloom.
Approve.
Let the record reflect that the minutes were unanimously approved by the commission. I think as everyone knows, but I'll just restate it here, we did not meet in February at the previously scheduled special hearing for the PFAS rulemaking due to an unopposed motion to vacate that scheduling order and pull that hearing down. We're going to start. We've got a number of items set up for a status conference. We're going to start with case number 23580. That's the application of Wild Earth Guardians to consider proposed amendments to address perfluoroalkali and perfluoroalkali substances and their use in oil and gas extraction, and amending 1915-2, 1915-16, 1915-31, and 1915-32 are all the parties who've entered an appearance in that case here today. Can we start with, well, have the parties decided who's making a report on the status of the case and what the next steps are? Mr. Tremaine?
I think I can start there, Mr. Chair. This is Jesse Tremaine for the Oil Conservation Division. The primary reason for postponing the previous hearing was to allow additional time for the Oil Conservation Division to obtain expert witnesses. We are in the very final stages of that, finalizing contracts for those services. Expect that to be completed any day. Additionally, we have started stakeholder engagement on aspects of the petition and structure, specifically with the other parties entered into the case, related to aspects of that petition and structure that don't require the expert services. OCD has been talking with both the industry stakeholders and the petitioners to suggest a potential alternative petition structure. So far, those discussions have been, I think, productive. We expect to need another 30 days or so to try and hammer out some areas of consensus. And I've put together a very brief kind of outline of all alternative dates. But where we are right now is that we're seeing the OCD has some availability constraints in early July. And we think that hearing dates in June might be a little difficult to provide enough time for the parties to work through the process. And I believe that the petitioners may have some conflicts witness conflicts in July. So my suggestion, and then I'll turn it over to the other parties, is to that we continue to work through a schedule and agree here to submit a revised pre-hearing or scheduling order as we did previously to the commission once we can kind of hammer out some of those conflicting availabilities. So essentially, as of right now, the division would be proposing potentially the week of June 24th, but I think that's going to be tight for a lot of the parties to work through, or one of the last 2 weeks in July. And I think the other parties have some conflicts there. So we're going to need a little bit of time to work through that.
Mr. Davis or anyone else, any comments on Mr. Tremaine's presentation?
Thank you, Mr. Chair, Commissioners. We agree with Mr. Tremaine about continuing talks about potential revised petition. The petitioners do have some witness conflicts in late June through July and early August. But I spoke with Mr. Tremaine, and we're going to go back and speak with one of our witnesses and see if we can either work that out with him or potentially work that out with parties, and either bump the hearing up by a few days or a week if possible, and if not, we'll hammer out a new procedural order to present to the commission.
Mr. Felderwart, for the industry parties.
I agree. I know that there has been some movement towards, having some discussions and having stakeholder meetings that may take a little time to see what consensus we can reach. Obviously, we have not had any discussions about any particular dates. So it does seem to me that we need some time to have those stakeholder discussions, try to figure out if we can come to a consensus on when witnesses can be available for a hearing day. So it might be premature to schedule something at this point.
Hearing the discussion, and I'll turn it over, I would suggest to the parties, maybe email myself and the hearing clerk some weeks that you're looking at. We can circulate that among the commission via email to confirm commissioner availability for a special hearing. Based on prior discussions, I suspect we'll probably want to reserve a week. And I think the commission's preference would be to reserve continuous weeks. So, no party has a weekend overlap one way or another, depending on you're looking at as we're managing it. And if you give us, 2 or 3 options, the commission can confer and tell you what works for our schedule at this juncture. But it sounds like it would be helpful. And absent any additional discussion or questions from my fellow commissioners, I think we'll just put this on the agenda for the April meeting, which maybe the parties, if everything's worked out, can just present an updated scheduling order that just has changed dates and other components. But if there are any other changes the parties would like to discuss, you're obviously free to propose those as well. Do I have any other questions from my fellow commissioners?
No, Mr. Chair.
No, Mr. Chair.
Mr. Chair, this is Dina Bennett. And I apologize, I'm not there in person.
Yep.
I'm a little sick today, but I did just want to enter my appearance on the record for EOG. We are in this rulemaking for EOG, and I don't have anything substantive to add to the discussions, but I did just want to enter my appearance for the record. Thank you.
Thank you. Sorry, I missed your hand. I just didn't check the screen, but duly noted. And I assume the parties will reach out and coordinate with Ms. Bennett now that she's entered an appearance. With that, we will move on to, we actually have a slate of cases involving similar parties having entered appearances. Those are cases 24277, 24278, 23755, which was a referral to the commission of a number of division cases by the director of the Oil Conservation Division. At this point, I'm not proposing that any of those cases the chair is not suggesting that any of those cases go together, other pieces. I'm actually looking to the parties for some robust discussion about the best way to handle these cases and other components so we can look at scheduling a hearing on the merits for them. So have all the parties who have entered appearance in those cases, are they either in the room or online?
Yes, Mr. Examiner, Dana Hardy. I'm here on WebEx on behalf of Empire Petroleum, and I believe Ms. Shaheen and Mr. Padilla are in the hearing room.
They are. And I see Mr. Tremaine for the Oil Conservation Division and Mr. Rankin for Goodnight Midstream. I'm going to open it up to discussion, and I think I'll start with Mr. Rankin and then move to Empire and then to OCD to provide some perspective on these or some suggestions about how we want to unpack scheduling questions surrounding these cases.
Thank you, Mr. Chair, Commissioners. Good morning. Adam Rankin with law firm of Pollen and Hart here in Santa Fe, representing Goodnight Permian Midstream LLC. Yes, Mr. Chair, we have 18 cases now that have been referred to the commission. One of them is a de novo case that is on appeal. Two of them are direct applications to the commission in which Goodnight Midstream is seeking to amend Monument South unit orders addressing the unitized interval and the special pool that was designated for that unit. I think it would be helpful, given the scope of these cases, Mr. Chair, if I would be permitted to have a few minutes just to kind of give a historic overview. I think putting this into context would be very helpful. It will lay out, I think, a basis for what we think is important and the procedure and the issues that we think need to be addressed by the commission. So with permission, I may just, if I may, take a few minutes to walk through the history a little bit here and explain why we think these cases are so important.
I'm comfortable with that, and similar time will be given to the other parties to help with some perspective on scheduling and other pieces.
Thank you. Mr. Chair, these 18 cases before you are much more than just a dispute between Empire and Goodnight. On their face, the cases represent a dispute over whether disposal in the San Andres Formation within and around the unit is doing two things: watering out the overlying Grayburg within the unit due to purported communication with the San Andres where water is being injected for disposal, or impairing water flood operations due to the chemistry of the water that's being injected, and somehow impairing Empire's ability to recover residual oil that's allegedly locked away in the San Andres and immobilized after millennia of water sweeping through the zone. These are the claims Goodnight's making, and they give rise to highly technical issues that we're going to have to deal with on the merits at a hearing when we get to that point. Our view is that these claims have no basis, and we're eager to get forward to the hearing, but there's a lot to work through before we do. Exactly how we got to this point in this dispute, how injection into the San Andres has given rise to this conflict, it's extremely important to understand, and I think that's why I want to just walk through the history here. The dispute is a culmination of an historic error, in our view, that was committed early on, decades ago, by the commission and has been repeated and perpetuated through time. And by historic, I mean in both senses of the word. It was from decades ago and also historic in the sense of the scale, the proportion of the error. Now, the consequences were maybe unseen at the time or not understood or appreciated, but nevertheless, it was an error and they haven't been corrected. The San Andres in this area, in and around the MSU, was first designated as a pool when the Eunice pool was discovered back in 1929.
I'm not Irish, dude. And if I did,
Chris.
Oh, sorry.
So the pool was discovered by a well drilled about 2 miles south of the unit. Okay, and that well was drilled and completed in the Grayburg. But at the time, the division included the entire pool going down to the base of the San Andres as part of an oil pool. However, all documented production in this area is from the Grayburg or Lower Penrose. There is no documented production from the San Andres. There never has been. The Starting in at least the early 1950s, if not earlier, the division started authorizing disposal into the San Andres in this area. By the 1960s, the division had approved disposal in the San Andres in and immediately adjacent to what later became the EMSU. In 1965, the state engineer declared the Capitan Basin an underground aquifer and included the San Andres within its definition of that basin, almost 2 decades before the unit was ever created. The division to this day recognizes the authority of the state engineer to approve wells and completions that would draw water from the San Andres. By 1984, nearly 30 SWDs have been approved for disposal into the San Andres in this area. That means for each of these SWD wells, the division must have ascertained that this disposal into that zone would not cause waste, would not impair correlative rights, would not remain, and the injection would remain the targeted injection zone. Okay, all that would have had to been discerned for approval of each of those wells. Then in 1984, the commission issued 3 orders on applications that were filed by Gulf Oil. The first one created a special pool within what was defined as the EMSU unit. That included the lower Penrose going down into the Grayburg, and below that, the San Andres. A second order approved a statutory water flood that unitized for water flood operations those same intervals. The lower Grayburg, the lower Penrose, the Grayburg down to the base of the San Andres. The third order, even though in that order, the source of the water flood water was the San Andres, and the water flood operation was authorized only for the Grayburg because that was the only zone where the oil column was located. The third order authorized water flood operations and injection within the Grayburg using San Andres water within the unitized interval below the Grayburg. Our view is that creating the special pool and the unit to include the San Andres was legally invalid. The express testimony at the unit hearing was that the oil column was limited to the Grayburg and the lower Penrose formation. It did not extend into the San Andres. Water flood operations would target the oil column in the Grayburg and lower Penrose formation only. Gulf proposed to include the San Andres in the unitized interval in the testimony simply because it was historically included within the pool and the San Andres would serve as the source of water for the Grayburg water flood operations. In short, the unit and its special pool were erroneously approved by the commission at that time to include the San Andres when it was already an approved and active zone for disposal and a known non-hydrocarbon bearing aquifer. Around this time then in the 80s, early 90s, the division officially designated the San Andres in this area as a disposal pool for disposal of produced water. In doing so, the division confirmed what was already known about the San Andres. It is a water bearing only zone. Since then, many more SWDs have been authorized for disposal in this pool in reliance on the division's designation and its findings in the history. In fact, within the designated San Andres, at least 98 wells within that pool have been designated for disposal, many of which are still active, most of them are, and many additional proposed SWDs are still pending. These historic contradictory determinations is what has brought us here. Okay, we have a unit that erroneously included the San Andres and a history of approval of saltwater disposal wells and a designation of a saltwater disposal pool that overlaps that same unit. Empire and Goodnight just happen to be the 2 players on the stage at this moment, but there are many others who will be impacted by the decisions the commission has before it today. So what I'd like to do just real quick is kind of show you what I'm talking about.
Mr. Chairman, I'm going to object to the presentation of this argument. Mr. Rankin is going into the historical, he's not limiting himself to the historical development of the Eunice Monument South unit. He's making an argument that is improper at this time. We're here, as I understand it, to schedule and determine how in the world, how we're going to schedule all of these 18 cases. But to go into an argument about the position of Goodnight, Goodstream, and attacking the original order as some being in error is not appropriate at this time. This is status conference to determine how we're going to decide these cases in the procedural for trying this case is not a opening argument or closing argument of the original cases.
Mr. Padilla, point duly noted. Mr. Rankin, I appreciate the context and history. I think it was helpful and will allow similar time for Empire to provide some perspective. We do have 18 cases. Deciding how we're going to consolidate them, move them together, sort of carry them forward. Having a little bit of background was helpful, but I think we'll pause there, Mr. Rankin. I think we're verging into arguments on the merits, but the history was helpful, kind of setting it and looking it out. And with that, Mr. Padilla, Ms. Shaheen, and Ms. Hardy, will turn it over to Empire for some just initial commentary on how we should be thinking about these as then we look to think about how we schedule it forward, if you would like.
Thank you.
Mr. Chair, and I can speak here for Empire and see if Ms. Shaheen or Mr. Padilla have anything to add. This unit that's owned by Empire in this area is approximately 40 years old. It was approved by the BLM, the State Land Office, and the Division and Commission. So it's a long-standing unit. It can't be unilaterally amended as Goodnight seeks to accomplish here. We've filed a motion to dismiss their applications that seek to do that for that reason, as well as the reason that they lack standing because they don't hold an interest in the minerals in this area. So the BLM, the State Land Office, and the Commission all found that this unitized interval was prospective for hydrocarbon production, and that has been in effect for over 40 years. So to come back now and allege that all of that was erroneous, I think is not going to be supported by the evidence, and that's the history. It's a longstanding approved unit. And with respect to the pools, and Mr. Padilla may be able to address this more effectively than me, but the pools have also been recognized as hydrocarbon pools. It's not an aquifer as Mr. Rankin has represented. Disposal has been authorized in certain areas, but it is also an oil pool that's recognized. And the nomenclature orders discussed that and determined that the Grayburg and St. Andrews should both be included. So I think that was a well-reasoned decision. It's longstanding, and Goodnight seeks to undo those decisions here. It's too late, and it's a collateral attack that I think is inappropriate and will be unsupported by the evidence. So that's Empire's position. And we can talk about how we would propose to schedule the cases if you would like, unless you'd like to hear from OCD or Mr. Padilla and Ms. Shaheen have anything else to add.
I think consistent with how we teed it up, I'd turn it over to Mr. Padilla or Ms. Shaheen if they'd like to add any sort of historical context.
Mr. Chairman, I think that Ms. Hardy has pretty much expressed our position in these cases. And we're looking at trying to set aside something that's been in existence 40 years. 1984 is when the unit was approved. After notice and hearing, I was astounded that I was involved in that hearing and reading the transcript. So that ages me considerably. But the inclusion of the San Andres and the Grayburg in pools in southeast New Mexico is common. We filed yesterday a motion to dismiss the two applications, and I don't want to argue those now, but including our argument on the aquifer and that kind of thing, that's that's in the motion to dismiss the two applications in cases 24277 and 24278. So with that, I think we ought to get back to the discussions that Mr. Rankin and Dana Hardy had yesterday in terms of trying to weed out they're more informed, or Ms. Hardy is more informed about proposed scheduling, and she has been in contact with our client and is more, she's just more informed about a proper procedure to proceed.
Okay. Mr. Tremaine, do you have any opening remarks for OCD or?
Yes, Mr. Chair, thank you. So the division, several of these cases, or many of these cases were before the division, and with the division hearing examiner, and the division did not engage at that time. So we've recently entered appearance and have taken up these cases due to a number of concerns. And basically that's a preface to say that I think that OCD is going to require some time to develop a fully fledged perspective on these. There's a number of issues that we've already highlighted of importance to the Oil Conservation Division that we need to look into at a very high level. The claims in these cases may implicate formation-wide SWD development, whether that's currently permitted SWDs, whether that is pending applications or future injection. The details remain to be seen, but clearly those other developments are implicated by these claims. OCD is also looking at potential implications for drinking water and any actions that the division needs to take regarding its primacy agreement with the EPA. And just as a practical matter, we're talking about 18 cases here. The core technical issues of the claims are complex and will take some time to develop in and of themselves. But I do note some variation in the fact patterns between the various cases. And so I think when we start stacking disputes over the various fact patterns, we're looking at either a series of hearings or potentially a very long single hearing here, which creates some scheduling concerns for the division. And lastly, at a very high level, and this is really a trailing issue, but it is one of OCD's concerns that implications for the production and development in the area may impact Empire's ability to comply with a current agreed compliance order for inactive wells, in which some portion of those remaining wells are required to be returned to production. So at this point, Mr. Chair and Commissioners, we have somewhat more, or I say many more questions than answers. But our expectations, I think, going forward are due to the factual complexity. I would ask for, before we move into any actual hearings, about 60 days for the OCD technical team to fully develop a position and move forward. I do also anticipate potential the need to resolve any open discovery disputes. OCD is not currently engaged in any such dispute, but being aware of the subpoena history and exchange of information in this case, I do have general concerns about diving into a substantial hearing if any of those issues remain open. So my recommendation to the parties in the commission is to engage in a somewhat more structured approach here, where the parties can agree to, or the commission can issue a scheduling order, providing for a somewhat more process than is typical. We'd recommend a period for discovery, briefing, and then motions to help decide how these cases will proceed, whether they're going to be 18 of them or split up into different chunks. And I think the appropriate timing for that decision is probably out at the end of the discovery and briefing period, and then set the cases for hearing. That's my recommendation.
I'll share some preliminary reactions and then or some preliminary questions based on the presentation. Clearly sounds like 24277 and 24278, the two applications to amend, which I know are subject to a motion to dismiss. I don't believe the Goodnight has had an opportunity to respond to the motion to dismiss, and other components may present one discrete set of issues that sounds like may be appropriate for resolution first, but would welcome the party's perspective on whether those two cases and the resolution of them can be separated from 23775 and the, for lack of a better term, bundle of cases involved in that, can go forward separately. Also, sounding from the presentation by the parties, information that I'm aware of in my capacity as the division director, and sort of other components. I think the commission would at least initially be looking at the parties to propose a scheduling order to us. I think this is a more substantial set, even just based on the preliminary presentations here, a more substantial hearing than just our typical 1 or 2 day slot allows on a Thursday, Friday. So preliminarily, I'd welcome the party's perspective on whether they think this is sort of a special hearing date, what should be included in the special hearings, and then prospects for the parties to come in with a robust proposed sort of agreed scheduling order that addresses all of those issues would sort of be my questions. I'll look to my fellow commissioners to see if they have anything else on these.
No, Mr. Chair.
No, Mr. Chair.
I'll turn it over to you, Mr. Rankin, to start and then go through the parties.
Thank you, Mr. Chair. Mr. Tremaine has brought up the point that I next wanted to make, and I think it's important for the commission to understand the scope, understand how best to attack or address these competing issues, because understanding the scope will help us, I think, narrow our focus to what is manageable and what is appropriately addressed in the first instance. And Mr. Chair, I agree with you, and I agree with Mr. Tremaine that the claims and issues raised in these cases implicate far more than the Eunice Monument South unit. And I'd like to, if I may, just show a picture, because a picture is worth 1,000 words, and I think it will help put into context the issues for discerning how best to manage the schedule and the procedure. May I share that screen? It's a map that shows the unit and offsetting SWD wells, including our wells and wells that are not included in this proceeding. If I may show so you can understand that maybe.
Do any of the parties have any concern with the presentation of the map?
No, Mr. Chairman, but I don't want him to go into an argument as to.
Understood.
I'll stay away from the argument, and you can tell me if I get too much into argument, but I just want to show you the map, okay? This is a map that shows the monument trend. In red outline here where my cursor is hovering over, this is the EMSU unit. This is the unit that issue in these cases. The orange triangles and squares are the wells, SWDs. The triangles are active injection wells. The squares are pending or proposed SWDs, and the orange color represents wells operated by Goodnight. The red triangle well in the center here is a disposal well operated by Empire, and all these wells inject into the San Andres Formation. So what's at issue in these cases are the orange wells that Goodnight operates, and what's excluded, but it hasn't been addressed by any of these cases, are the other SWDs injecting into the unit, in and around the unit. These green wells are operated by Rice. This yellow well is operated by OWL, and they all inject into the same zone inside the unit or immediately outside the unit, in many cases closer to the unit boundaries than Goodnight's wells. So this, I think, map articulates the problem and the scope that Mr. Tremaine referenced here. The claims at issue are that this area that's defined as the Artesia Fairway and within that green boundary is what Empire's experts say is a potential residual oil zone. So all that area is potentially, according to them, subject to tertiary recovery through, for an ROZ. So there's no principal basis to distinguish between wells inside the unit or outside the unit. So what I would propose, Mr. Chair, is that in order to reasonably tackle the cases before us, is that we first focus solely on the wells injecting into the unit only. And to do so, I think in order to accurately and fairly discern the claims, we need to include more parties. It can't just be Goodnight. There are 3 other wells and operators injecting into the unit boundary currently into the same zone. Since the 60s, more than 110 million barrels has been injected into that same area. And if there's concerns about watering out, those other parties must be included for the commission to make a fair decision about, who's up. If there is any communication at all, if there is any watering out, we need to have all those parties involved. So my proposal, Mr. Chair, is to first address only the unit. Allow us to hear the issues that are being raised. And at that point, if there's a finding that there is ROZ, that there is communication between the Grayburg and Sandress, then we can proceed to look at wells and cases outside the unit. Those wells and cases outside the unit are going to have individualized analyses that we're going to have to discern based on the geology, the engineering, other factors that will influence the radius of influence of the injection in those wells. That is going to bog this process down if we have to get into these individualized issues, evaluating the impact potentially of each of these wells on the injection and whether it reaches the unit boundary. So it'd be far easier and a more straightforward approach just to limit initially to the unit boundary, and then we can address the claims going forward from there. So that's my pitch. I do think
Mr. Rankin, what cases just before, in your view, would cover wells within the unit question and wells within the unit? What case numbers?
So there are a total of 18 cases, Mr. Chair.
Yep.
Of the wells and cases that are in the unit that I think should be included in one shot. Let me get to my list. Sorry, a moment. I do have a list. Because I wanted to make clear what those cases were. Let me find my list. So Empire has 4 cases that address injection within the unit boundary. Those are 24018, 24020, 24018 through 24020, and 24025. Those are applications to revoke current SWDs within the unit boundary.
And those are, just for the record, those are division case numbers.
Those are division case numbers.
Yep.
Now, Goodnight has a number of cases that also deal with injection into the unit boundary, and there are 8 of them. And those are case numbers 23614 through 23617. And it includes 23775, which is a application to increase the rate of injection in one of the wells. It also includes the de novo case, which is case 24123. I believe that's the commission case number. And then it also includes our Goodnight's applications to amend the EMSU orders, which is case numbers 24277 and 24278.
So just for my own clarity, and obviously we'll let the other parties hear, it would be Goodnight's proposal that a package of cases for hearing would be commission case number 24277, commission case 24278, which are the applications concerning the unit, and then a subset of the cases within commission case 23755 to include division cases 23614 through 23617, 24018 through 24020, and 24025, which is in all of the cases that are currently sort of referred up as 23755. And then lastly, the commission case 24123, which is a de novo case, would be sort of a package for hearing. And your proposal is that anything else that isn't in that enumerated list would be subject to separate standalone hearings subsequent to those?
Yeah, I haven't necessarily articulated a position on whether those remaining 6 cases should be each standalone separate cases.
Okay.
I'm not saying that that's the case necessarily. I think we may be able to find a way to streamline or address those together, but there are going to be individualized issues within those 6 cases based on the location of the wells. And again, I believe it's improper to address those 6 cases without consideration of other SWDs that are closer and similarly situated to Goodnight's injection. So I think those cases should be appropriately addressed at a different time. The one thing I did want to point out, Mr. Chair, and there is it's a little confusing on the agenda, but on the agenda where it references case 23775, it doesn't actually include the description for that case. It seems to imply that there are other cases involved with that, but it's a little unclear. I just want to make sure that's for the record that the way that the case caption was articulated there for that case was incorrect, and happy to help with staff to make sure that's correct going forward. But that I think was a little unclear and maybe provided some confusion about what cases were currently being discussed today.
I think we'd be open to some follow-up feedback on there, and obviously the case number tracking here, because we're dealing with a number of division cases and a number of commission cases, would need some clarity as we move forward with scheduling. Ms. Hardy, I'll turn it over to you for Empire's perspective on scheduling and packaging.
Thank you, Mr. Chair. Mr. Rankin, I think at the initial part of his discussion just now recognized that there's no basis really, there would be an artificial distinction to separate the wells outside of the unit from the wells inside the unit, because it's all one area and the formation is the same. So I think that from our perspective, it would really waste resources of the parties and the commission and division to separate out the wells injecting outside of the unit from the wells injecting inside the unit. They're all impacting the unit, and I think you could see from Mr. Rankin's map, some of them are right outside of the boundary. So I think that would be an artificial distinction that's not necessary to make. I think it makes more sense to hear all of the cases at once, because the issues really are the same. It's one pool, and the issue is whether Goodnight's injection into those wells or proposed injection is impairing correlative rights or resulting in waste. So I think that it would waste resources really to separate those out. I don't think it's necessary, and I think it's an artificial distinction. So I think it would really be more efficient just to hear all of the cases at once, even though there are a lot of them. I don't think the issues will be that different. In fact, the parties already filed testimony in the division cases, and the issues overlap extensively, almost entirely. So I think that would make more sense. And I think that we would propose, and that the parties, and I had run this idea by Mr. Rankin and Mr. Tremaine, we discussed it, would submit written testimony along with their exhibits, as we do currently in division cases, and then submit written rebuttal, and we could work out the dates for those submissions. We were talking about a hearing potentially in August, if that works for the commission. And I think that handling the testimony and exhibits that way would significantly cut down on the amount of time required in the hearing, and it would also clarify the issues so that the commission would have everything in front of it when we go into the hearing. And I don't think that the number of cases should really control. I don't think that breaking them out really makes any sense.
Thank you, Ms. Hardy. Mr. Tremaine?
Mr. Chair, I frankly can see merit to both arguments, putting them all on at the same time or breaking out the EMSU cases. In talking with the technical team, I think that their OCD would be amenable to approaching the EMSU cases. I mean, we're still talking about, I think it's 12 separate cases there. And without making any determinations or proclamations about the technical nature of the various different applications, it's my understanding that the parties are going to argue, at least some of the parties are going to argue, that those cases not included in those other 6 cases have distinct facts. And I do see that as the presence of that argument is extending that, that hearing. The core technical issues and the claims between all of the cases are, I think, quite similar. So going forward with the EMSU cases would provide a foundation for the other cases. And so I could see us going either way. I think the hearing is likely to be more efficient if we break it out with the EMSU, but that's not a strong position. Frankly, we'll accommodate either the will of the commission.
Next question, I suppose. Do the parties believe there are existing discovery disputes and information sharing that needs to be resolved prior to hearing? We'll start with Mr. Rankin again.
Thank you, Mr. Chair. We are working diligently on discovery. As you may be aware, we did both parties served discovery back in 2023 in advance of what was originally scheduled to be a division hearing. And we did pause that hearing in light of discovery disputes that came to light on the eve of the hearing. And so as a consequence of that, the cases have been stayed while we were continuing to work through negotiations conferring over discovery. I think we've reached I think we basically have both parties have, I think, gotten to the point where I think we've satisfied that discovery request. Since that time, Mr. Chair, 10 new applications were filed by Empire, and we filed 2 additional applications. So the scope and scale of these issues has increased. We served recent discovery last week on Empire. I believe that they intend to serve discovery through the division on us again. I believe that we have probably one more round ourselves to do to ensure that our experts have all the information they need. I do believe, and I want to flag this for your attention today, Mr. Chair, but I do believe that there's a chance, a likely chance, that we will also move for pre-hearing depositions to take certain depositions of Empire's witnesses in advance of a hearing. And we'll lay that out as and when we need to, because we believe that the circumstances here are extraordinary and would justify pre-hearing depositions. But we'll want to wait to make sure that we can justify that with some additional discovery. So we are endeavoring to get that done. So as Mr. Tremaine noted, I think there's a lot left to do and sort out technically. And we want to go forward with the commission, and we're eager to do so. But we want to put on a case that allows the commission to fully vet these issues. And to do so, we just need to make sure we have the time and the resources and get the information ourselves. Empire here is in the driver's seat. They are the operator of this unit. They have all the information from their predecessors, the chemistry, the petrophysics, the cost, the modeling, things that we would need to do to put together an economic demonstration of what they claim is not viable. So we're working towards that, Mr. Chair. And I think just wanted to just kind of raise some of these discovery issues for you. I think we're working well together, and I think we can get through it. But I do think it's going to take some time. So I'm hopeful that by the end of June, we will have what we need for discovery. And then, and that's why when I was speaking with Ms. Hardy yesterday, I was thinking potentially August would be a good time frame. I actually appreciate Mr. Tremaine's recommendation that we wait and see how things go with discovery and briefing, to make sure we are in a position to proceed to hearing. And so my recommendation would be that we set monthly status conferences with the commission just to make sure we're on track, that there are any discovery issues or disputes that we can attend to those quickly and get them addressed. And that we can also, I think the parties should confer and propose a time frame for legal briefing. I think it's important that the commission have our viewpoints, if we can't reach agreement, on what issues need to be decided so we can properly frame the dispute. And then we can lay out the legal issues, such as what standards apply, who's got the burden of persuasion and proof, how's that all going to proceed, and are there additional necessary affected parties? So I think there's a lot to brief on the front end, and there's a lot of discovery to do. So my recommendation is that we take the next month for the parties to confer on a scheduling order. And then at the next meeting, Mr. Chair, we propose either what we can agree to, and if not, that we come up with a schedule for briefing to address these legal issues and procedure.
Ms. Hardy.
Thank you, Mr. Chair. The parties are engaging in discovery. I do want to flag for the commission, and I mentioned this to Mr. Rankin yesterday, that we will be filing a motion regarding Goodnight's recent subpoena. I think It's duplicative. Some of it goes way beyond the scope of this proceeding. So we will be filing a motion on that. And I also want to flag the fact that this is not a civil litigation proceeding. There is civil litigation going on between Empire and Goodnight, in which extensive discovery, of course, is occurring and will occur, but this is not that proceeding. This is a commission administrative proceeding that involves impairment of correlative rights and waste under the Oil and Gas Act. So I think it is much more limited than, of course, civil litigation. So although the parties will engage in discovery, and I agree that some discovery is needed, I think that sort of a free-willing inquiry into all types of matters is not appropriate in a commission proceeding. This is an administrative hearing process with limited discovery by rule. So I do want to mention that. I think it does make sense for the parties to communicate about a schedule and try to propose something to the commission. I do think that an August hearing date would make sense. And I think it would be helpful for the commission to set a hearing date so that the parties know what they're working toward and will stay on track. Because as we know, sometimes when there's not a hard deadline, things don't get done. So that's where I think Empire's coming from.
Mr. Tremaine. Thank you, Ms. Hardy.
Thank you, Mr. Chair. I don't expect that OCD is going to weigh in on any discovery disputes, but hearing that there's a likely motion to quash and pending further discovery requests to be exchanged, I would say that OCD's only real concern is that that discovery is resolved before we get into briefing and hearings. So just reiterating my request that a hearing earlier in the summer does not seem practical or effective. And we don't want to engage in an extended hearing if there's discovery disputes occurring on the eve of that hearing. So I think I would concur with the tentatively proposed August date. The only other thing, the commission just heard about the PFAS rulemaking petition. I would just like to highlight for OCD's staff dedication that having two separate 2-week hearings within the same month period of time is going to be extremely taxing on the staff. So I will be working with the parties to try and schedule those relative hearings with a little bit of break in between so staff can do their regular work as well. That is just an overarching concern. We'll have preparation in advance. So these two hearings could take 3 weeks out of OCD staff time in the middle of the summer.
Thank you, Mr. Tremaine. At least from where I sit, and I'll turn it over to my fellow commissioners, I'm not sure. I think there's a little bit more work for the parties to do to kind of unpack scheduling and other components before the commission just unilaterally says we're going to do a hearing on X date and Y date and other pieces. So at least right now, my inclination is to set these for another status conference in April with the direction that I would like the parties to come in with ideally a full scheduling order that gets it. That sort of sets it together, but at a minimum, a scheduling order that resolves any pre-hearing motion deadlines, schedules, kind of other pieces, because I think the commission is going to need to set that in the near term to move these cases along. I would also ask the parties to send us some dates for the hearing. Again, based on the discussion here, this sounds like something where the commission will need to reserve a week potentially of hearing time, and being mindful of my own and my fellow commissioners' schedules. We're going to need some proposed dates to sort of put in and look at and nest it in with other components. So those would be kind of the two key elements that at least I would encourage the parties to focus on so that we can set a robust scheduling order and hearing date at the April commission meeting. It sounds like the parties are close, but not quite there. And I personally am inclined to allow a little more time to let the parties sort those things out and then provide the commission with some dates that might work so we can buck that up against commissioner availability for the main hearing and then set some motion hearings and other components in between. And if there are additional information exchanges under the rules provided for the Oil Conservation Commission, sort of contemplate that in sort of the initial schedule. Ms. Shaheen?
Thank you, Mr. Chair. I just want to mention that this was originally set to be heard before the division in November. And I'm concerned, with all due respect to Mr. Rankin, that Goodnight is using discovery disputes to extend the time for hearing. And Empire is willing to go to hearing on August. But I'd just like to note for the record that the longer we take to get to hearing, the more advantageous it is for Goodnight. It continues to inject water on a daily basis in large amounts. And it's a disadvantage to Empire for us to keep kicking the hearing out. So I would only note for the record that I'm concerned that discovery disputes will continue because it's advantageous for Goodnight. And I encourage the commission to set a hearing date in August when we do reconvene in April. Thank you.
Thank you, Ms. Shaheen, duly noted. Again, at least from my perspective, I think I understand the value of setting a hearing date, if only for my co-commissioners, sort of scheduling and planning purposes, but also a desire to move these cases along. Commissioner Bloom, Commissioner Impoma, any thoughts on these scheduling questions?
Mr. Chair, I have nothing to add at this time. Thank you.
Mr. Chair, I believe you covered it well. Like, we need to have all these days advanced so we can plan accordingly. So thank you.
Mr. Rankin?
Mr. Chair,
Mr. Rankin?
I must address the allegation that we're delaying. We are not delaying. Since that case, those cases were ready to go to hearing. There are 4 cases ready to go to hearing in November. Since that time, we identified some serious concerns around discovery. Okay. When we asked for certain documents, they gave us documents on ROZ in Lithuania. Okay. It was a joke. Since that time, they filed 10 applications to revoke Goodnight's injection wells. That's a much bigger scale. There's a lot of discovery to do and to get at the root of their claims. It is not a delay. So I just want to respond to that because it's a serious allegation. We are interested in fully vetting the claims, and there's a lot of material to go through. And so that's what we want to present to the commission, is a full vetting of these issues.
Duly noted, Mr. Rankin. Again, I would encourage the parties when they come back in April to have some more specific thoughts about open information exchange issues that are there as it pertains to the cases that are currently before the commission that are potentially up for hearing, and then at a minimum come in with a proposal for a hearing date so that we can work backward for motion resolutions and other components, because I think both the commission, and I can say this because I referred the cases up in my capacity as division director, there was a desire to resolve these cases, which is why they were referred up, and they were referred up because of the cross-cutting implications for injection and production operations in a significant area. So I think we're aware of the gravity here, but I think that's the direction to the parties for the next one. And obviously, if the parties can come to an agreement on a full or scheduling order, great. But again, at a minimum, we will want to address ultimate hearing date and some initial dates for motion hearings and other components to start teeing up these issues for a hearing, because I am persuaded by the arguments there that when we're in the actual hearing, we want to get to the merits of the factual disputes and have resolved sort of outstanding information exchanges heading into that. So with that, is there anything else to add on these cases? Otherwise, we'll move on to the next item on the agenda. Thank you all. I'm going to give us just a 10-minute break, and we will reconvene to go into the case that's set for hearing today, 23655. So we will reconvene at 10:10. Thank you all.
Thank you.
Now, so it's fun.
Can you hear me, Sheila? Okay, good.
All right, everyone, let's go ahead and resume. Good morning. We are moving on to our affirmative case that's actually set for hearing. Case number 23655, application of the Joint Industry Technical Committee to amend order number R111P, Leonetti Counties, New Mexico. I'm not going to read the very long caption. Order R111P is long established, or actually order R number 111. There is a detailed caption in the agenda. Counsel for the commission, Mr. Rubin, had to step away for a court scheduling conference. He will return, or a brief court hearing. He will return as soon as that's done, but we'll proceed. I believe there are 3 parties that had entered an appearance in this matter. The Joint Industry Technical Committee, the Oil Conservation Division, and Strata Energy. Have I missed any parties? Okay. Seeing counsel for the parties here, I will turn it over to the applicant, Mr. Feldewert.
Thank you, Mr. Chair. Good morning. I handed to each of you R111P as it appears on the division's website. So the font and the text that you see is not my doing. That's what you get when you go to the division's website. And that was enacted in 1988, as you noted, under case 9316. And since that time, this order has governed the drilling of oil and gas wells in what's called the known potash leasing area, the KPLA, which sits down there in Eddy and Lee counties. When you look at this order, it consists of the following components. Pages 1 through 4 of R111P is a series of findings, paragraphs 1 through 23, which provide a background for the adoption of this rule back in 1988. Beginning at the bottom of page 4, you'll see a series of paragraphs A through J. And those are the rules and regulations that were adopted back in 1988 and which currently govern the exploration and development of oil and gas in this known potash leasing area. And it is these paragraphs, some of these paragraphs, that we seek to modify here today. Then you'll see an exhibit A to this particular order towards the back. And it is a listing or a lengthy legal description of the known potash leasing area in Eddy and Lee counties. It's about 8 pages. We're not changing any of that. Then exhibit B to this order, which is at the very end, contains a 10-page statement of agreement between the potash industry and the oil and gas industry, which was referenced by the commission in 88 and is referenced in their order and was included as what they said, background information for the adoption of the rules. So that's what we currently have. You should also know that this KPLA area is not just governed by order R111P. There's also a secretarial order that was issued by the Department of Interior in 2012 that governs federal lands in the known potash leasing area. But we're here today to address R111P, which has not been without controversy over the years since its enactment. Some of you may have been aware of that controversy. I was involved in the in the 90s and early 2000s in various disputes under R111P. However, with the advent of horizontal drilling and the establishment of BLM drilling pilots, that controversy has largely died down. And this period of cooperation has resulted in the formation of the applicant here, the Joint Industry Technical Committee. And it consists of representatives of the potash industry and representatives of the oil and gas industry. This particular committee is also recognized in that secretarial order that I talked to you about, the BLM secretarial order. And a technical group of this committee has met over the last 5 or 6 years to develop modifications to R111P. And they utilized experts from both industries, the potash industry and the oil and gas industry, to come up with these modifications, which they believe will improve the practices for the safe and responsible concurrent development of oil and gas within the known potash leasing area. These modifications we presented to you in our filings as JIT Exhibits 1, 2, 3, and 4. Exhibit 4 contains the rule with all the proposed modifications that we asked to be adopted. And let me briefly discuss the interplay here between Exhibits 1, 2, 3, and 4. So what we initially did is we took this wonderful order on the division's website, converted it into a Word, and then took that and began to do the modifications in red line strikeout format. So if you look at what we filed, which begins on page 10 of our 180-page PDF file last week, you'll see the modifications to this R111P that were initially proposed. And the yellow shaded and underlying text is what we had proposed add to the rule. And the red shaded text with a line or strikeout through it signifies the text that this committee has determined should be removed. And when you go through that Exhibit 1, you're going to see significant red lines. And that's because the committee developed new anti-collision measures, more stringent well casing and cementing requirements for the surface casing string, the salt protection string, the intermediate casing string for deep oil and gas wells, and the production casing string. He also put together new notification requirements to potash operators. There's new subsidence monitoring requirements in this rule. And then there were various edits that were necessary to update, clarify, and actually correct some of the text of the rule to conform with the proposed modifications. So Exhibit 1 is your anchor back to the current rule. Then Exhibit 2, when we filed our application, we took those red line strikeouts and made a clean version, and that was our Exhibit number 2. But you can largely ignore that now. And that's because since the filing of that Exhibit number 2, there's been a lot of discussions between the parties who entered an appearance. Strata Production Company, the division, and even the Joint Industry Technical Committee, in looking at that Exhibit 2, noticed some additional corrections and that needed to be made. So since the filing of our application, there has been some good, productive wordsmithing that resulted then in some red lines to what we filed as Exhibit number 2, and that is Exhibit number 3. So I want to be clear, that starts on page 33 of our PDF. Exhibit number 3 shows the modifications to what we filed as Exhibit number 2. And recall, Exhibit number 2 is a clean version of the modifications that are shown in Exhibit 1. These additional changes in Exhibit number 3, again, the added language is shown in either red or blue text and underlined. The language removed or changed is shown with a line or strike through it. And when you go through Exhibit number 3, you're going to see some language that's highlighted in yellow. And the reason we left that in there is because that was language that the division proposed should be added or stricken from the rule. So for example, if you go to page 1 of Exhibit number 3, you're going to see yellow text where we added the word production. If you go to page 10 of Exhibit number 3, there's some language that was added to paragraph I-5. It's highlighted in yellow because that was language that the division requested, and I'm going to let them address as needed, but I understand that this limits the burden on the division to monitor drilling locations when BLM drilling islands and development areas are used by oil and gas operators. So that's what Exhibit 3 is. And then Exhibit 4 is everything. Exhibit 4 is the final proposed rule with all modifications accepted. It begins on page 45 of our PDF. This is what we asked the commission to adopt as the new rules. Now, when you look at that Exhibit 4, we've included within that legal description towards the end. But when you go to that legal description, and I just noticed this the other night, you'll see it's an Exhibit A, just like we took it from R111P, but you'll see the top. It says Exhibit A, case 9316, order R111P. When you adopt this rule, and we hope we do, you're probably going to need to change that heading, okay? Then we've included, and let me share here, if I may. Can you see that in front of you? Okay. So that's that Exhibit A in our Exhibit 4 that, we'll need to change that heading, okay, when the new rule gets adopted. The other thing you'll see with our Exhibit 4, and this was in our initial filings, but they've been modified somewhat, and that is we included an Exhibit B to the proposed order, and it is a series of wellbore diagrams, figures A through F, and they begin on page 65 of our PDF. These diagrams are referenced in the proposed rule, and they were referenced and they are added because we believe they will assist those who are reading the rule to understand the wellbore integrity requirements. So we encourage you to adopt these figures as part of the rule to make it very clear what is now required or what will be required in the known potash leasing area. So before I move to our other exhibits, are there any questions about that interplay between exhibits 1, 2, 3, and 4?
No, not on my end. And just to clarify for the record, the only error or some in Exhibit 4, the proposal from the JITC is to adopt that as a R111Q if we were to approve it, and just some clerical errors cleaning it up. But Exhibit 4 includes everything that you would propose including.
Yes, sir. And I do agree. And this was at the end of my spiel here. But while you're on that, I would encourage you to adopt it as R111Q for a couple of reasons. One, for historical reasons. So we maintain the evolution of this, and also make it easier to tie back to the prior rules. So if our system allows you to do it, which I hope it does, hopefully this could be R111Q. Okay. All right. Then we have our next 4 set of exhibits. Exhibits 5, 6, 7, and 8 are the self-affirmed statements of the witnesses that we have offered in support of these rules. There are 2 witnesses from the potash industry, and there are 2 witnesses from the oil and gas industry. And each witness was involved in the development of these proposed modifications. Exhibit 5 is the self-affirmed statement of Dan Morehouse. He's here today. He was the mine engineer for Mosaic's potash mine near Carlsbad for many years. And we believe his credentials qualify him as an expert witness on potash mining and the potential impact on mining operations and potash reserves from oil and gas development. Mr. Morehouse was a member of what they call the Wellbore Integrity Working Group within the JITC that developed the technical aspects of this proposed rule. And Mr. Morehouse, in his self-affirmed statement, discusses the JITC, the applicant here. He discusses the consensus building, the significant consensus building that resulted in these proposed modifications. And he's here today for any questions that you may have about that. Okay. Exhibit number 6 is the self-affirmed statement of William Morgan. He's employed by Intrepid Potash and was previously a completions and production engineer with Mewbourne Oil Company. We believe his credentials and background qualify him as an expert witness in oil and gas drilling and the potential impact on potash mining and potash reserves from oil and gas development. He discusses in his statement kind of what I went through with JIT exhibits 1 through 4. And he also discusses the new subsidence monitoring provisions that are placed within this rule. He's here present by video if you have any questions for him. Okay. Exhibit 7 is the self-affirmed statement of Greg Caraway. He's employed by Occidental Petroleum as a reservoir engineer advisor. We believe his credentials likewise qualify him as an expert witness in oil and gas drilling, reservoir engineering, and the potential impact of oil and gas development on potash. He was also a member of that working group that developed the technical aspects of these proposed rules. And he addresses the changes to Section C, which is requirements for drilling in the potash area. He summarizes the new anti-collision measures and the new casing string requirements in subpart D, as in David. And he addresses specifically Section E, which discusses the fluid to be used while drilling through the salt section. He addresses the new notification requirements to potash operators in Section F. And he discusses the changes in Section H to the cement used for plugging wells. He's also available by video if you have any questions on those topics. Exhibit 8 then is our self-affirmed statement from Alex Podas. He's a well servicing engineer advisor with ExxonMobil. His credentials qualify him, we believe, as an expert witness in oil and gas drilling and the potential impact on potash. He was a leading member of that work group within the JITC that developed the technical aspects of these proposed rules. And he addresses most of those technical aspects in the key provisions. For example, the new anti-collision measures in D2, the surface casing string requirements in D3, the salt protection string requirements in D4, as well as the 2 well bore design methods that are provided to operators and are part of the figures that are attached to the rule. He addresses the intermediate casing string requirements in D5, which includes the wellbore diagrams associated with the 4 design methods that the rule provides to operators. And then he addresses the more stringent standards for the production casing string in D6. And you'll see that he also then developed our exhibits 9 and 10. Exhibit 9 talks about the separation factor, which is discussed and utilized in the new anti-collision provisions. And then Exhibit 10 talks about more specifically and addresses with some text the figures that you see as A through F in our proposed modifications. Mr. Podas is here in the room if you have questions for him. Then our remaining exhibits deal with notice issues. Okay, my exhibit 11 and 12. And I think it's important to point out that since these rules are not statewide rules, okay, they are limited to the potash area. Therefore, the notice requirements are actually found under the adjudicatory provisions, which is Rule 4 of the division's rules, and specifically 19.15, 0.4, 0.12, A5, which is labeled special orders regarding any division designated potash area. That's what we have here. And they require that notice be sent by certified mail to all potash lessees, oil and gas operators, oil and gas lessees, and unleased mineral owners of record within the designated potash area. The Joint Interest Technical Committee compiled this notice list of affected parties from the BLM email list that is used for all potash notices. So that's a pretty good source. And then the records of the potash companies and the oil and gas companies that participated in this Joint Industry Technical Committee. We also included notice to the BLM and to the New Mexico State Land Office. So Exhibit 11 is my affidavit reflecting that notice of this application was provided to this extensive list. We also note that we included more than one address for some affected parties to be overly inclusive. And we included email addresses where we could not find a mailing address for a particular party. Again, that email address coming from the BLM. Exhibit 12 then, and this is the last exhibit, is the affidavit of publication from two local newspapers, the Carlsbad Current Angus and then the Hobbs Sun News. And the notice of this application, the notice of this hearing was directed by name to each of those affected parties. So that's what we have provided to you. And I think it's important to know that these proposed modifications is a culmination of years of cooperative study and collaboration between the potash industry and the oil and gas industry, done by experts from both industry. And I think the testament to the collaborative effort is the absence of any objection to these proposed modifications. And we believe that the evidence presented demonstrates that the adoption of these proposed modifications to R111P will promote the safe and responsible concurrent development of oil and gas and potash within the known potash leasing area. It'll prevent the undue waste of commercially recoverable potash in oil and gas resources and protect relative rights. So I request that exhibits 1 through 12 be admitted into the record and that the commission adopt the new rules that are reflected in our exhibit 4.
Your request to put those exhibits into the record is granted. I'm going to turn to Mr. Tremaine for some opening remarks and then Ms. Shaheen.
Mr. Chair, I'll be very brief. We concur with Mr. Felderworth. This has been a long, collaborative, and iterative process. OCD entered appearance to ensure that certain concerns and updates were being proposed. The division has long engaged with the JITC generally and has had input in this process generally, but more specifically responded with specific but limited edits and comments to the initial proposal. And so as far as the proceedings of the hearing today, we intend to participate and make Mr. Powell, OCD's deputy director, and Mr. Phil Getz, the UIC program manager, available if the commission wishes to engage with any questions regarding OCD's comments, feedback. But in sum, the scope and extent of this process and then the inclusion and the manner in which the applicant addressed OCD's concerns with the edits, which are now reflected in exhibits 3 and 4, do adequately address OCD's concerns. And so OCD is here to support adoption of the of exhibit 4 with reliance on the information and testimony provided by the witnesses presented by the applicant.
Thank you. Ms. Shaheen?
Thank you. Strata likewise concurs with the proposed amendments as they're set forth in exhibits 3 and 4. It appreciates both the JITC participants and OCD's engagement with Strata's concerns and joins in asking that the commission adopt the amendments to the rule as proposed.
Thank you. I guess I'll start with maybe just sort of an open question, both to my fellow commissioners and the parties. The JITC's application materials, I found them to be comprehensive and detailed in terms of written testimony and other things like that. So in terms of just managing the proceedings here, would like to proceed, would like some thoughts from the parties and other things like that, areas where we have questions, need to present witnesses versus we're comfortable with sort of the representations in the records or other pieces. What's the sort of plan here, since it sounds like we have some consensus update or suggestions about the need to put, and I am mindful of the need to ensure that the commission has a robust record sort of before it. And I do want to hear from my, fellow commissioners about their thoughts about the filings and areas where they may have questions before we move into the next steps.
Mr. Chair, yeah, this is a little bit different than some of our other hearings because we have consensus in front of us, and kudos to the parties here. It's not often that we have complete agreement between oil and gas, potash, and the OCD. So this is wonderful. Which I know you'll get into this a little bit more, Mr. Chair, about how we'll proceed today. I may have I will have one question about the anti-collision measures. When I reviewed that, I just couldn't quite get my head around that. But my questions would be limited to that. Thank you.
Dr. Impel.
Chair, thanks so much. So I'm still reviewing through all the materials, and as Commissioner Bloom said, it's so exciting to have a consensus here. And I also do have some few questions with regards to wellbore diagram, and then also the subsidence monitoring. Probably limit my questions to those pieces. Thank you.
So it just sounds like, at least preliminarily, the commissioners may have questions for Mr. Caraway. And I forget who discussed subsidence and Mr. Morgan.
Yes.
But Mr. Feldewert, question posed to you about thoughts about proceeding there, but it sounds like we may want to hear or at least pose some questions to those witnesses.
Yes, and that's why we're here. I mean, first off, in my humble opinion, the commission has in the record what it needs to adopt the rules, because we were purposely very specific in making sure that we covered what we needed to cover. This can be a fairly short hearing, but we do have the witnesses available to discuss the topics that for which you have questions. And when you're ready, we can proceed to do that.
Mr. Tremaine and then Ms. Shaheen, any concern with just calling the witnesses for whom the commission has questions and otherwise relying on the written statements filed in the record?
No objection to adoption and noting the written testimony and proceeding directly to questions or any cross-examination, Mr. Chair.
No objection from Strata.
Even though I know it was presented in a different order in the filing, I think we'll call Mr. Caraway, who I believe you said, Mr. Feldewert, is available online.
Yes, sir.
I'm going to ask the court reporter to swear him in when we've confirmed that he's connected via audio. Mr. Caraway, can you confirm you can hear us and speak?
Yes, I can. Can you hear me?
We can hear you and we can see you. Thank you very much.
Perfect.
I'm going to ask the court reporter to swear you in.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. And Mr. Caraway, just for the record, but I'd like you to just confirm it for the record, what's in JITC Exhibit 7, your self-affirmed statement. Can you confirm that you prepared that statement?
Yes, I did.
Did you work with anyone or get help with anyone on it?
I think Mr. Feldewert helped to adjust some of maybe the verbiage of how I had written some of the testimony.
But it otherwise reflects your opinions and positions on the matters discussed therein?
That is correct.
Based on the self-affirmed statement, and unless there's an objection from the parties, I'll just note for the record that the commission will recognize Mr. Caraway as an expert for the purposes, expert in petroleum engineering for the purposes of the matters discussed in his testimony. And I'm going to turn it over to Commissioner Bloom to pose his questions concerning your written statements.
All right. Thank you, Mr. Caraway. Appreciate your time today. Can you hear me okay?
Yes, I can.
All right. Thank you. Could you just walk me through the separation factor? I believe there's a simple mathematical equation that represents that, and explain to me how this helps prevent or ensures that there are not collisions.
Sure, and I'm happy to provide the testimony on this. I think Mr. Potus actually may be the better witness to testify to this.
Yeah, let me interject, not knowing what the question was, yes. If the separation factor and actually the exhibit on that separation factor was done by Mr. Potus.
Well, then I think we should hear from Mr. Potus. Yes.
Okay.
Unless there's other questions for Mr. Caraway.
Do we have any other questions for Mr. Caraway? Do we have any other questions for Mr. Caraway? His testimony also covered surface casing strings, but I believe more detailed discussion is also Mr. Potus, the salt production casing strings and sort of other components. Is there anything in his testimony that we have questions on? Otherwise, we'll call Mr. Potus.
Yes, I do.
Okay. Commissioner Mpoma?
Thank you. So the first question will be, in your statement, you talked about only new casings are recommended instead of used. So I would like to hear more about, the process that you went through to more or less come to that conclusion.
Sure. So during the discussions with our counterparts in the mining industry, we talked through a little bit about what used versus new casing means and what some of those implications are. The main reason that we decided to adjust the verbiage to new casing was that with new casing, you are there are a set of standards with minimum wall thickness that are going to be achieved with that casing. And so given the criticality of the casing integrity in these areas, we wanted to make sure that that there wasn't any opportunity for substandard casing to enter the wellbore and provide a potential reduction in the integrity of the well design. So that's why we proposed that we would that any casing installed should be new casing to maintain the integrity and make sure that we do meet the minimum requirements that are desired for this design.
Yeah, thank you for that. So now my next question will be, are there any proposed modification to existing well completions, based on the response that you gave?
I don't believe so, not at this time in the way that we complete the wells.
Yeah, so then in that case, what is the impact of the existing completions? So you have new completions coming in with more advanced completion technique, and you do have existing wells more or less probably with suboptimal completions. So what is the impact, where you have new ones and then existing ones? So what is the impact, in terms of the integrity on what we are trying to prevent here?
And I'm not sure that I understand the question.
Let me rephrase that. So you do have new completion techniques that you wanna, let's say any new completion, any new drilling would have to follow this new completions. My concern is, what about the existing completions? And how are they, going to impact the overall program that you're trying to, more like the amendments. How are we going to achieve the objectives of these amendments when you have these existing completions still in existence?
Sure. So I think that with the way that we've reworded the requirements, I think that, in my opinion, the current and potential future completions designs need to fit within those design requirements. And under the current conditions of our design requirements, they do fit within the design, and to make sure that we do have a sound engineering design to maintain the integrity of the well.
So you talked about evidence-based waiting time of the cement. So how are you going to quantify that, or how are you going to measure that?
Sure. So what can be done is on a batch, when we run a cement blend, prior to running it, we can start doing a test as well on that actual cement through a laboratory test, and model it under the same conditions that are going to be present in the wellbore. And we can monitor what that cement integrity will look like at a specified time, and understand the compressive strength that cement has gained over that time period.
So I presume we will run something like CBL to quantify the integrity of the cement as part of the process too?
Not necessarily, no.
Okay. Yeah, so if not necessarily, then what is the evidence-based? Because you talked about you can do, once you are planning, you can do all this modeling in the lab to more or less know the cement integrity. But what is the evidence-based right at the site, the field, whilst we are drilling, that we are going to use here?
Sure. So as an example, for the salt strength, that's of concern, the cement should achieve cement returns to surface. And then we did have some modification to the language with the division's input that if and when cement is not returned to surface, then additional things like a CBL would be required.
I looked through the wellbore designs. These are really comprehensive. So are these options for operators to choose, or there is more stringent option, or all these? So you've presented multiple of them. So are these alternatives, and are there any processes for, let's say, an operator to choose which option they want to use?
Correct. So the intent was to give operators flexibility, but also, again, maintaining the integrity of the design and the processes to make sure that we would maintain the integrity of the design. So as an example, in general, one of the requests from the potash miners was to be able to monitor for potential pressure on the backside. And so all of these designs reflect the ability to do so, to understand long-term what is the integrity of the well.
Thank you so much. Mr. Chair, thanks.
Any other questions for this witness? Seeing none, Mr. Caraway, Mr. Tremaine.
Yes, sorry, Mr. Chair, just to clarify my question here. I'd just like to clarify with the witness that the proposal would require a 4-string in the Capital Reef. Oh, sorry, Capitan Reef.
Yes, I believe that that was one of the modifications that we made with the division's input.
That's my only question, Mr. Chair. Thank you.
Mr. Chair, can I clarify? So, but I do see 3 strings in there as an
Correct.
option. So not necessarily 4. 4 is an option, but 3-2 is an option here. So if we can clarify that.
Sure. So the Capitan Reef is does not cover the entirety of the KPLA area, and so areas outside of the Capitan Reef, a 3-string is possible. The division's concern was in areas where the Capitan Reef is present, that there be a 4-string requirement.
Mr. Caraway, for the record, can you tell us where that requirement is reflected in the proposed order?
I may be able to help. Go ahead, Mr. Caraway. I believe I have it up.
Yes.
Do I have it up on the screen, Mr. Caraway?
I believe so. Yes, that's and that's actually highlighted, I think, is the verbiage that we included at the request of the division, that a second intermediate casing string required in areas of the Capitan Reef.
And I believe that's page 39 of our 180-page PDF.
Perfect. Any additional questions for Mr. Caraway? Hearing none, or seeing none, Mr. Caraway, you may be excused.
Thank you so much.
I'm going to call next Mr. Alexei Podest. Please come up. And then I would ask the court reporter to swear Mr. Podest in.
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes. Mr. Podest, as I did with Mr. Caraway, just for the record, because of the nature of how we're posting it, can you confirm that, bear with me one second, that the statement provided in Exhibit 8 was prepared by you?
Yes, it is.
Did anyone assist you with the statement?
Yes, Mr. Felderworth helped me, modify some of the wording, but the statement is all mine.
Thank you. For the record, and based on the statements in your self-affirmed affidavit, the commission will recognize you as an expert in the field of well development, petroleum engineering, and other pieces for purposes of the matters covered in your statement, unless there's an objection. Seeing none, I'm going to turn it over to Commissioner Bloom for his questions about the anti-collision measures.
Okay, thank you, Mr. Post, for your time today. Not sure where to begin with this one, but I know there's an equation, and I think Mr. Felderworth said that it might be referenced here in one of the exhibits. Is that correct?
Give me a minute. I'll try to get to the language. There we go. Can you see that? Oops.
Yes, I see the language.
I believe it's going to be in the PowerPoint slide attachment. That's part of my witness testimony.
Okay. So I'm going to move to JIT Exhibit 9.
Yep, I think it's the next page there. Is that the one you were talking about right there on the slide?
That is the one. Yes. Perhaps if you could walk us through that. I'd actually, I was doing a little bit of research, found a slightly different equation, but if you could walk us through that, that'd be a great start. Thank you.
Well, I can just, do I need to provide any background on what's, on wellbore surveying, or just talk to specific equation.
Yeah, I mean, let me tell you where I'm going with that. So I mean, you could have a situation where a separation factor of 1 or just greater than 1 could be well bores just essentially right next to each other, correct?
So it's, when you're talking about wellbore surveying, right, it's a statistical analysis, right? So where your wellbore survey is calculated at, and then the ellipse of uncertainty separation forms a three-dimensional shape where with 95% certainty, you can say that the wellbore is located.
Okay. And then I guess where I'm going is I just want to understand what ensures that there's not a collision. And is there a minimum distance, for example, that has to separate the wellbores?
There's not a minimum distance because it comes back to the ellipse of uncertainty and the specific tools that were used for the surveying and the errors that are associated with those tools. The ellipse of uncertainty is formed because the surveying tools that you use are not perfect. There's errors associated with them, and the survey is a series of measurements as you go down the well, and those errors accumulate, so the ellipse of uncertainty grows. And you cannot really say with 100% certainty where a given wellbore is located. So the 95% rule is the industry adopted, commonly adopted number.
Okay. Is there, perhaps the language is elsewhere, perhaps it's in OCD regulations that show us how wellbores are separated. You know, the equation that I saw for separation factor was this AD divided by AB plus CD, where AB and CD are the wellbore radii, and AD is the distance between the centers of the wellbores. And I mean, if you're at a separation of factor of 1, I mean, those wellbores are just about kissing, right? I mean, they're real close.
No, not necessarily. So the separation factor of 1 means that the ellipses touch, that there's contact between the ellipses. And each ellipse of 2 wellbores represents a 95% certainty where that wellbore is located. So a separation factor of 1 means contact of the ellipses, but does not mean contact of the wellbores.
And is there any minimum distance required between wellbores?
Again, we don't define the minimum distance between the wellbores because it, again, depends on the size of the ellipses. If you have a very inaccurate tool, then that ellipse is going to be very large. Whereas if you have a very accurate tool like a gyro survey, then you have a lot of certainty where that well is located, and that ellipse is going to be small. That's why when we talk about anti-collision, we don't talk about distance between wells because of that statistical uncertainty concept. We talk about ellipse uncertainty and the separation factors, or sometimes distance between the ellipses of uncertainty.
Okay. Well, I don't understand how we know our wellbores aren't colliding, but we haven't seen protest from the OCD. I'll take their word for it that we're not going to see collisions out there. Maybe Dr. Impel will explain that to me at some future date. No further questions. Thank you.
Yeah, let me try to rephrase my question that I asked earlier. So we do have the existing rules, which was enacted 1988. So I presume there are existing wellbores in this area that is producing oil and gas in this area. Is that correct?
Correct, yes.
So my concern or question is, with this new regulation, or more like more advanced completion techniques that we're going to more or less implement to safeguard the existing or to safeguard the potash. What will be the impact of these existing wellbores that do not follow this new improvements that we are more or less passing through this hearing?
I will say that this regulation, it mostly deals with new wells that are being drilled and are being completed in the practices of contemporary wells. It sets requirements for well design and well operations practices of the wells being drilled today. So it does not really talk about the wells that are currently in existence and producing at this point.
So do you believe that this new, definitely we all believe that this new completion is going to ensure integrity of our wells that we are going to drill into the future. Now, assuming I have existing well bore 1,000 feet, that does not conform to this new completion style that we are proposing today. I just want to understand the impact of that, comparable to, let's say, the new well bores that conform to the high standard.
Again, this standard mostly deals with the drilling and the hydraulic fracturing operations on new wells.
Okay.
So it does not, I don't believe it's going to put any existing wells out of conformance.
So just to understand that, then it means we are learning from the drilling of the old wells and then the problems that occurred during those drilling periods, more or less assisted the joint industry team to come up with a new design to more or less support, to improve the integrity, to more or less curtail any previous problems that occurred in the past.
Yes.
Okay.
Absolutely. We incorporated all the learnings that we have collected since 1988. This R1MP has been in place for a very long time, and the industry has moved on significantly since then. And there's a lot of new technologies and new operating methods that have been developed, and all that has been incorporated into this update. So we have incorporated all of those learnings into this new standard.
So the monitoring techniques that were proposed in the new rule, is that going to apply to the existing wells too?
The monitoring rules, which section are you referring to?
So I will ask more about the subsidence, but I do know that in the completion, we do have open session where we're saying that it is more or less for monitoring in the new well bores that I've seen. So those monitoring, are the old wells going to be required to also implement the same monitoring strategies or not?
You're talking about section G, subsidence monitoring, right? Is that what you're referring to? Just clarifying.
So I'm more or less looking at the completions. So the exhibit B, the wellbore diagrams, I'm looking at those. And you see that there is open analysis that is going to be more or less for monitoring purposes. I believe that is what I read. So I just want to know the existing wellbores, are these monitoring strategies, proposed monitoring strategies also going to apply to that as well?
I understand your question. So it depends on the well design. So this is applicable to new wells being drilled. Once a well is drilled, if it doesn't incorporate an open annulus, if the annulus was cemented up, then no, that monitoring is not possible. So the wells that are currently in the ground are grandfathered in.
Well, let's talk about that. So I do know that this new completion style more or less support strict monitoring. Now, the existing ones, if we cannot, let's say, monitor through the annulus, what about if it is pressure that we are measuring? Is that not, can we not put it along the tubing of the production well?
Yes, I mean, the tubing by production annulus is going to be monitored, and the wells that, I can speak for ExxonMobil, the wells that we're currently producing, we are able to monitor those wells. So this introduces additional means of monitoring the wells. So this is an additional annulus that can be monitored. So it's not saying that the existing wells are unsafe. We're just saying we're introducing additional safeguards to make new wells that we're drilling even safer.
Thank you.
Any other questions for this witness? Mr. Feldwer?
Mr. POTUS, I want to go back to the separation factor. Okay. Now, was there any discussion about, having a set minimum distance within the group?
Set minimum distance between the separation factors?
Between wells?
No, and that's really not the industry standard. That's really not appropriate for the reason I discussed.
Okay.
It really depends on the size of that ellipse of uncertainty.
All right.
How accurate your survey of that well is.
So you and the other experts that were on the Wellbore Integrity Working Group, right?
That's right, yes.
Okay. Those included experts from the industry and the potash company.
Correct.
Both of which have their own means to ensure that there's sufficient rules to prevent wellbore collision, right?
Yes, so each company is going to have their own set of anti-collision rules. This just sets the minimum requirements. And I'll just point out, this is an entirely new section, so there was nothing on anti-collision in the R111P at all. So this is all new requirements, and again, this is minimum requirements that are set forth, and each operating company is going to have their requirements that will often supersede these minimum standards.
And was it the opinion of the Wellbore Integrity Working Group that this separation factor would protect against collisions?
Yes.
And is it your personal opinion that this separation factor that has been developed in collaboration with the other experts, that it will prevent wellbore collisions?
It will minimize the risk of a collision event.
Okay, thank you. Hold on. That's all I have. Thank you.
Thank you. Any additional questions for Mr. Podest? Ms. Shaheen?
None from Strata.
Thank you, Mr. Podest. You may be excused. I think the last witness we spoke about wanting to pose some questions to was Mr. Morgan concerning the subsidence monitoring. I believe Mr. Morgan is available online. Mr. Feldwer?
Yes.
Mr. Morgan, can you confirm that you can hear us and have audio?
I can confirm I hear you, and can you hear me?
We can hear you and we can see you. I'm going to ask the court reporter to swear you in.
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Good morning, Mr. Morgan. Just like with the prior witnesses, can you confirm what's been entered as applicant's exhibit 6 reflects the statement that you prepared?
Yes.
Did anyone assist you in the preparation of that statement?
Mr. Feldwer helped with some language, but the content is mine.
And based on statements in your self-affirmed written statement that was filed, the commission will recognize you as an expert in the field of completions and engineering and production engineering And with that, I'm going to turn it over to Dr. Impoma with some questions.
Thank you, Mr. Chair. So I'm looking at the section G. I'm looking at page 9, where we do have the subsidence monitoring. So my first question will be, do you believe that the content there is significantly enough to really address any potential subsidence issues?
So it's my opinion, and keep in mind, this is a new provision here that requires subsidence monitoring where otherwise that would not have been in place. So it's truly a provision to observe and be able to collect data on any potential subsidence activity in and around the potash area, but this would allow for warning signs of any subsidence activity that can have negative effect on producing wells in the area. So not so much that it is preventative of subsidence, but it is an alert. So that new provision being in there is all aimed to alert operators within the potash area to potential subsidence concerns that can be monitored and reported.
Yeah, so in the write-up, I do not see any recommended tools that has been tested, to be more like effective in actually measuring or monitoring subsidence. So based on your discussion, was it more like left it open to the operator to decide whichever tool they want to use?
Correct. That is my understanding. There's various subsidence monitoring tools. I'm certainly not an expert in that field. However, that is my understanding. It's left up to operator to make the decision on how to fulfill that requirement, knowing that subsidence monitoring for wells within 1 mile of an active mine in the KPLA needs to be observed.
So will you agree with me that it will be appropriate if we add, let's say, a statement in there saying, giving the authority to NMOCD to more or less vet that tool that is actually going to be utilized, to catch up more or less with technology?
Yeah, I think that it needs to be probably discussed more, but as far as who has the authority to observe or impose what specific tools or observation tools need to be put in place, it would need to be a collective effort. But I can't speak on who should have authority to implement specific tools and devices.
Yeah, so at least you believe that there should be a wording in there, more or less. I don't know who's going to discuss with regards to who has the authority to assist. So I'm not saying that NMOCD should impose which technique, but at least they have to have an oversight on which device that the operator is more or less going to use.
I definitely see the reasoning for input on that from all parties that are a part of the group.
And one concern I had with this is that you stopped right at the end where you said just an alert, right? It's just going to provide an alert. But what happens if we see a subsidence, and what is the magnitude of the subsidence or the displacement that we should see? That should be of a concern. And if there is a concern, what are the next steps that needs to be followed?
Yeah, that is a fair point. And in my discussions and working in the group, that piece of what next has not necessarily been addressed in this new provision.
So how do we address that?
Good question. I don't know how to answer that at this time.
I really, really want us to think about that because it is a great provision, but I feel like it is short of the device? And then also, what is the displacement magnitude that we should look out for? And if we supersede that magnitude or displacement, what are the next steps? This is a critical monitoring tool or monitoring strategy that I believe needs to be complete.
Understood.
Thank you, Mr. Chair.
Mr. Tremaine, do any of the witnesses for OCD, would they be in a position to answer some of these questions, how that information might be used?
Mr. Chair, I think that OCD witnesses could speak to, potentially to OCD's response. Mr. Powell can speak to how OCD would respond to an alert, shut-ins, emergency orders, et cetera. When that occurs, my understanding is the subsidence is more of a mining concern, and the actual monitoring of subsidence may not squarely be within the expertise of the OCD, but if you wish, we can make Mr. Powell available to flesh that out more.
Thank you, Mr. Tremaine. Any additional questions for this witness? Seeing none, Mr. Morgan, you are excused. Mr. Tremaine, is Mr. Powell online?
Mr. Powell is available through WebEx, yes.
Mr. Powell, can you confirm that you can hear us and have audio?
I can. Can you hear me okay?
We can hear you and see you. I'm going to ask the court reporter to swear you in.
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Powell, can you just briefly state for the commission your current job and your background?
Currently, I'm the Deputy Director for the Oil Conservation Division, overseeing engineering and environmental programs. I've been with the division for almost 18 years now, ranging from an environmental specialist to engineering bureau chief, district supervisor, so lots of different avenues with the OCD.
Okay. Would you care to comment on Dr. Mpoma's questions about regulatory oversight in this area and how the OCD might respond to subsidence issues or and the like?
Sure. So subsidence monitoring isn't something OCD typically monitors. We think it's a good addition to this because it starts setting a baseline, starts setting something that we can watch. As far as what levels we would take action at, I think we would work with operators and work with the mines to look at that if we started seeing issues similar that we've done with seismic monitoring. So if there's subsidence that is being viewed or being seen during this, I would say the general expectation is for the operators that are seeing it to then get with the potash mines and with the OCD to report those and see what actions need to be taken, whether that be additional monitoring, whether that is actual action of regarding individual wells or how that is played out. I don't have that information because we haven't done subsidence, but I would think the first step would be is if we've seen something significant to report it both to the mines and to the OCD and then look at a path forward with that.
So Mr. Powell, just to clarify, it's your read of that provision that we're basically collecting data, establishing a baseline, but if there were actions needed to be taken in response to the data that was collected, that would require further collaboration and coordination between various parties?
That is correct.
Okay. Any additional questions for Mr. Powell?
Yes, I want to follow up and ask, so looking at that provision G, do you believe, and based on the discussions that I had with Mr. Morgan, do you believe that that provision, that provision currently in the rule is good enough at least for now?
I think the provision attempts to provide that notice as it refers to early warning conditions, but it could potentially use some revisions to identify if there are those conditions viewed, how the operator is to react to those.
Thank you for that. And do you also believe that at least NMOCD should have some oversight, not necessarily imposing, but oversight on what techniques is going to be utilized in the monitoring?
I think the OCD should be involved in that process, yes, because it will affect the wells and future development, potentially in an individual area or on a larger fashion to see if there's trends, those kind of things looked at. So yes, I think OCD should be involved.
Thank you.
Mr. Powell, can you tell me what the OCD's obligations are generally with respect to potash development?
It's to ensure that oil and gas. So I didn't prep anything. So this is just going off general memory. It's to make sure that oil and gas drilling and production don't negatively impact the potash drilling.
And
or the potash mining, sorry.
And Mr. Powell, what are our what's the OCD's general obligations with respect to oil and gas development?
It's protecting correlative rights. It's ensuring wellbore integrities. It's generally making sure operations aren't threatening in the environment.
Thank you. Any additional questions for Mr. Powell?
Mr. Chair, I just have a couple clarification questions for Mr. Powell.
Okay.
Mr. Powell, if OCD became aware of a significant, like an emergency issue, does OCD have the ability to issue temporary cessation orders to the well operators in the area?
We do.
And does OCD also have the ability to promptly issue emergency orders that may require operators to take additional steps rather than ceasing a current operational activity?
We do.
And if such a situation arose, if there was a significant subsidence alert or other monitoring issue that threatened either potash or correlative rights or presented the opportunity for waste, do you believe that the division is situated to respond promptly to issue either a temporary cessation order or an emergency order?
We do. And I believe industry is also committed to that through the formation of the Joint Industry Task Force Committee. And looking at that, I think it's in everybody's best interest to take appropriate actions.
No further questions. Thank you.
Any additional questions for this witness? Mr. Powell, you are excused. Mr. Feldwert, are there any other witnesses you'd like to call or question or talk? I know there's some sidebar discussions surrounding the discussions we're having here on subsidence monitoring.
What I would suggest is maybe we could take an early lunch break. If that works for you. And then I may or may not have something when we come back, but I don't anticipate taking very long.
I think I'm fine with that. It's 11:30. We will reconvene at 12:30 back in here and continue the hearing on this matter. Thank you.
Thank you.
Sheila, have you resumed recording?
Yes, we're recording again.
Mr. Feldowert, are you ready to resume, or we'll give another couple minutes for folks to return?
I have a couple minutes to be great.
All right. All right. Good afternoon, everyone. We're resuming the March 14th, 2024 Oil Conservation Commission hearing. We're on case number 2365, the application of the Joint Industry Technical Committee to amend Order R111P, Leonetti Counties, New Mexico. We had, prior to lunch, had some witness testimony, mostly to address questions posed by the commission. And I think where we left off was there were some questions about the subsidence monitoring provisions and other pieces, and how that data might be used or responded to. And I think there was an open question to the parties, whether they wanted to supplement any of the information they provided in response to those questions from Dr. Mpoma.
Mr. Chair, if I may, Michael Feldowert for the applicants, I would like to call Dan Morehouse, who has not testified yet. He did come all the way up from Carlsbad, so I'd like to have him come to the stand and address some of the issues.
Would the court reporter please swear Mr. Morehouse in?
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Mr. Morehouse, like we've done with other witnesses, did you prepare the self-affirmed statement submitted as or introduced as applicant's Exhibit 5?
Yes, with assistant counsel.
Do we need to, Mr. Feldowert, do we need to recognize him as an expert based on the questions you want him to discuss?
I would like to recognize him as an expert based on the credentials that he has in his self-affirmed statement.
Okay. Based on the credentials listed there, we will the commission will recognize the witness as an expert in mine engineering and engineering management. And with that, I'll open it up to questions.
Mr. Morehouse, you were involved with the development of these proposed modifications?
Yes, since the inception.
Okay. And a member of that Wellbore Integrity Working Group?
Yes.
Okay. And did you then assist, or were you involved on behalf of the potash industry in the development of what I have up here on the screen, which is subpart G of the proposed rule?
I was involved with all the discussion led up to it anyway.
Okay.
Yes.
Okay. And there were some questions here about the language that's used, et cetera. First off, the current R111P does not have any provisions dealing with subsidence monitoring, correct?
That's correct.
And is this something that the potash industry thought would be a good start to obtaining information?
Yeah, potash and oil and gas. It was another one of those consensus items that we all thought it was a good idea to keep our eye on that.
Okay. And the way this is written, what's the purpose of this provision?
Subsidence measuring has been done various ways over the years, but about 2010 and then a little after, new ways of using LiDAR and INSAR have come along to make it very much easier to do a broad subsidence. And we have looked at some information from that stuff, but we have no real conclusions drawn yet. We think we need to continue to watch it. And that's how this language got to be in the rulemaking, is that we felt it was just necessary to keep our eye on that. When issues come up, to bring it to the overall JITC or any other interested parties and follow through.
Okay. So if I break that down, if I look at the rule, it says shall be monitored. So it's a requirement now, correct?
Yes.
Okay. And as part of that monitoring, will the JITC be able to gather data?
We expect it to be used by, data will be gathered and it will be available to JITC and everyone.
And then the JITC can take that data and begin to analyze it?
Yes.
Okay. And in that sense, then begin the process of determining when action should be taken and what action should be taken.
Yes.
So is this like a first step in towards that process? Is you got to get the data first?
Yeah, a continuation of that step. We've barely begun it and it needs to be carried further.
Okay. And I think you testified, but just to make it clear, this data that's obtained by this mandatory provision, that is then going to be analyzed and utilized by the Joint Industry Technical Committee.
Yes.
Okay. That's all I have. Oh, let me, one last question. And Mr. Morehouse, as an expert here and having been involved in potash mining for a lot of years, in your opinion, is this the appropriate first step in dealing with the issues that you intend to address with this provision? Is this a good first step?
It's a good continuation of the steps. I can't say this is the first step because we've attempted to look at it in the past. It's a good way of moving forward.
Okay, great. Thank you. That's all I have.
Mr. Morehouse, so the data that will be required to be collected under G and will be available to the JITC, do you envision that the data will be reported to BLM and OCD or just available to them upon request?
I don't know that we've researched that, but it's definitely available on request. And I bet would be willing, if you wanted to set it up that way, we just send it whenever we have it.
Dr. Mpoma, do you have a question?
Exactly. Yes, I do have a question. So based on the testimony, it sounds to me that that provision is mostly for the JITC, but there's no clear provision, as to the role that the regulator is going to play in this. So I feel like this needs to be clarified in there to make sure that the regulator also has a role to play other than just the JITC to just review the data to come up with the next steps. The regulator needs to have a role to play in that. Would you assent to that statement or not?
My answer would be that the good thing about having something in here about it is that if we show a subsidence somewhere where people that aren't members of the JITC, or it should be every operator in the area out there should be, if we want to look at measurement, casing deformation measurements along the wellbore or something, it's any well out there. And I guess maybe you guys can do that independently if we bring up an issue. But having it in the rule here means that anybody that's out there drilling we may have issues and this is in there that they'll have to measure their well bore or whatever comes up out of the decisions. But I understand, we don't know what those decisions are yet. We just haven't gotten that far.
So let me ask you, with regards to the rule, is it, give me a second. Is it JITC going to enforce it, or is the regulators going to enforce it?
JITC will do it. Whether you guys tell us to or not, let's do it that way, but it's good to have it now that we know we need to do it.
No, I'm just saying that the whole provisions, the whole update that we are working through now, who is the enforcing agency? Do you know?
I don't know.
Okay.
Dr. Fulmer, I could probably address that. I mean, if we look at the rule, it says subsidence shall be monitored. Okay, so it's now mandatory, which means just like any other provision in this rule, it is enforced by the division.
Exactly. If it is enforced by the division, but according to the testimony, the data is going to be shared with JITC, and internally they are going to discuss and come up with steps as to what are the next steps, you know. But I feel like the regulator has to be involved in that.
Well, I mean, you can look at this a number of ways, but, as Mr. Morehouse testified, I mean, the first step is to get the data. So they don't have data now. And if you don't have data, you don't know what exactly you need to look for. You don't know what the thresholds need to be, and you don't know what needs to be done at each threshold. That needs to be examined. And that's the purpose of the Joint Industry Technical Committee. So they determined, again, this is something that's new, right? Not previously required. The JITC said, look, we want to make it mandatory that any well that meets this requirement, it shall be monitored so that we can obtain, so that we have the data and that we can start studying the data. And then from that point, and remember now, this JITC is made up of the industry, oil and gas industry, potash industry. Everybody's got the incentive to make sure it's done right, okay? And make sure that action's taken when actions need to be taken. So they set it up to get the data first. Now, what needs to be done at what threshold they don't really know yet. That's still being examined.
So subsidence is not really new. It's been around for quite some time. So based on your response, it sounds to me, my question would be, what were the best practices that were considered in drafting the language? Because if you look at our industry, a lot of casing collapse, a lot of, let's say even communication between injections or production zone and production zones specifically with regards to this. And then also, let's say, above formation and all of that, subsidence cause some kind of issues, in relation to those. So definitely there has been a precedence. There has been a lot of studies on that. So my question is, in terms of what were the best practices that the team that put this together, considered before coming up with a language?
That's a question I can't answer. I don't know if Ms. Morris, can you address what was looked at by the
To
committee?
a certain extent. The evidence we had for subsidence previously is, it's usually done with instrument surveys of some kind. And they're kind of anecdotal. You don't know everywhere subsidence is occurring until you go out there and measure in places. And we haven't universally measured anywhere. And the advent of LIDAR and INSAR has made it available to us to see where all is it going on and give us a more comprehensive. This is just much more comprehensive than anything ever done before on subsidence.
So I maybe have a question and a proposal listening to the discussion, back and forth. Agree that the provision here requires data monitoring and other collection. Acknowledge that obviously, at least on the OCD side, OCD has plenary authority to request data that's generated in the field. But I would wonder what the parties would think in it as a sort of subsequent additional amendment to G, listening to this, something along the lines of such data shall be reported at least quarterly to the BLM and the OCD as appropriate, except in the event of conditions that threaten the integrity of any active wells, which shall be reported within 24 hours of confirmation. Any remedial steps will be developed in coordination with the impacted operators, JITC, OCD, and the BLM. I think that provides a pathway for data coming in. Since the purpose here is to go to wellbore integrity questions, that's why I had a sort of separate reporting period there, because OCD's concerns at least jump up with wellbore integrity beyond sort of impacts on potash components. So, Crawford wanted to get parties' reactions, at least conceptually, to that sort of addition to G.
Obviously, the first, I don't know where you pulled that, but I'm impressed that you got that. Very good. And secondly, if you want to give me 5 minutes, we could talk about it, see if there's any issues there. Do you mind sharing that with me, or is it?
Yeah.
Okay, is that all right?
I mean, to the extent that you can read it.
Okay, yeah. So if you can you give me 5 minutes? Yeah. Okay, great, thank you. Yeah. From the scheme of it. You can testify first, but on the top of it.
All right, we're back.
Mr. Chair, a couple of comments. First, as you'll glean from the rule, there's, and this may go to some of the concerns, there's an existing provision that has a quarter-mile and half-mile setback from mines. Okay? And that purpose of that was to address concerns in part about subsidence. So in other words, if there's something that happens quickly, that setback was designed to address that. So what we're dealing with here then is beyond that, in dealing with trying to study on a long-term basis, and I mean a long-term basis, the subsidence that occurs further away from these mines. So what has been contemplated by the JITC is that they want to gather this data, and it's going to be more on a longer term scale. You're talking about, yearly or so. So what would make sense to them is to provide the data on a yearly basis to the division, because that fits more with, long-term nature of the study. The second part of the rule of your proposed language, it seems to me, is already addressed with other provisions in the division's rules that deal with casing integrity issues, which are required to be reported on other aspects of the division's rules. So the point being here that any subsidence over time is not going to have a 24-hour or 48-hour impact on casing, right? It's going to be something gradually over time. And any event that's going to be 24 or 48 hours in nature is already going to be addressed by the division's integrity rules. So our suggestion would be that really all you need is to add a sentence that, the data will be provided to the division and the BLM on a yearly basis. Because that's kind of when the JITC was planning on looking at it anyway. Because you're talking about long-term, miles away from any mine. So that's our response.
Okay. I'd be open to that, and I take the point about the casing integrity components. Any other questions for Mr. Morehouse? Mr. Tremaine?
I had just a general response to the proposals that have gone back and forth, not a question.
Go both.
So OCD is amenable to the structure. The yearly reporting does make sense. I think the line of questions from Commissioner Ampoma, I think really break down into two considerations. There's what to do with the data, and then there's how does the regulator know about the data. And so I think the open question is what to do with the data. And this updated proposal resolves that. The only hesitation we have is that this most recently proposed structure relies on the representation of the operator to indicate whether the subsidence was related to casing. Because we actually were talking about that. We think that OCD's casing integrity rules would likely apply to these scenarios. Subsidence may very well be related to casing integrity. The only issue with that is that it puts OCD in a position where it may not be able to determine whether it's associated with casing integrity or not. And so I think it would be more straightforward and simple if, there was a significant subsidence that caused a concern for potential casing integrity, that there was a shorter notification window. So the second section, more similar to the chair's original proposal, I think that would kind of thread the needle there.
Do you have a question for the witness?
No questions for the witness.
Okay. Mr. Morehouse, you're excused. Thank you. Any other questions for witnesses or other components? I had a couple of more general questions for the applicant that I think Mr. Feldort, you're probably going to be in a position to address. So I see what I'm holding here and looking at is the current version of R111P, which is on the division website that Mr. Feldort passed out. As I read Exhibit 4, which is what the applicant is proposing to issue, it basically provides replacement language starting at page 4, where it says, "It is therefore ordered that," all the way through sort of the end, through the exhibits, including the new exhibits. So what isn't there is the findings that the commission would make here. And in reading it over, you know, some of these are stale, at least in the chair's view, and then I'm not sure there's any relevance mentioning R111A or R111B when we're at R111P. And so I wanted to float in sort of reading through this, you know, up through paragraph 1 is sort of boilerplate, and it's there as I'm flipping through R111P. Paragraphs basically 3, 4, 5, 6, 7 can all be struck as they're sort of dated information, at least in my view, relative to you know, the circumstances that led to the amendment at the time. I wanted to ask in Exhibit 8, is it the applicant's view that what is currently Exhibit B to R111P should be retained, or is that sort of an artifact that can be dropped? It wasn't in your set.
Good question. In my opinion, that is an artifact that can be dropped for the R111P. It'll be it's already part of R111P, part of the history, but it doesn't need to be, doesn't really have anything to do with this proposal.
So paragraph 8 and 9 also seem irrelevant for findings. 10 through 17 with some maybe Scrivener changes for references retain relevance just in terms of setting context. They describe general authority. And then 18 and then 18 is more of a kind of summary statement about we heard testimony and comments reflected here to justify the amendments. 19, 20, 21, again, and 22 seem to be, again, artifacts of history, don't need to be retained. And 23 is just sort of a boilerplate language. That's sort of my thinking on an approach to what the order looks like. And what I'd like to float for discussion with my fellow commissioners, the R111P is an unusual vehicle. It's sort of written like a rule set, but it's a commission order. You know, probably if we were starting from a blank slate, they might even be special area rules. But be that as it may, we are where we are. I think it would be helpful for the commission and council and other pieces if we got native file versions of your Exhibit 4. Because I think all we have is a PDF. We've got a Word version. And I would actually like to propose to my commissioners, and I'll put it for discussion before we move it, but that I think there was sufficient evidence to adopt the applicant's proposal, which is Exhibit 4, with the amendment or some version of the amendment that we just discussed. I think Commission Counsel and Commission staff should go ahead and put together a draft written order that can be circulated to the parties in advance of the next meeting, so that we can come to a confirmation that everyone is comfortable and happy with the updated language, and they get to see both the findings from the commission and the proposed provisions, which are, again, largely consensus in applicant's Exhibit 4, and that we actually take action on the order at the April hearing once we've seen it written out. So I'm not even sure there's a need for a motion there. That's just a proposal on the table. Thoughts, reactions from my fellow commissioners?
Mr. Chair, that certainly makes sense to me. Thank you.
Mr. Chair, I do agree with that. Thank you.
So I think since we're not going to be approve it till we have it put together, I think the directions to the party then are after this, Mr. Feldewerd, if you'll provide us Exhibit 4 in native Word format, so we can incorporate it.
Where would you like me to send it?
Send it to the OCC hearings, the clerk's address.
Okay. Yep.
And then we will circulate it at least 2 weeks in advance of the April commission hearing, so folks can look at it as a totality, and then we'll plan to vote on it at that hearing.
Hopefully we won't need it, but will we have an opportunity to provide comment?
The intent here is I would intend to list it on the April docket as a matter that's open for hearing and comment. The purpose of providing it 2 weeks in advance is if there are red line comments to put in, we can go through it and we can, talk through any changes at a public hearing. But in looking at the old order, reading the new one, other pieces, I'd rather get it right than have to come back in and do like some technical amendments. So.
Yep. Thank you.
Mr. Tremaine, does that work?
Excellent proposal. Thank you.
Mr. Chair, since we'll be coming back on this, perhaps our next meeting or hearing would be a time when proponents could maybe take another crack at the anti-collision explanation. When I see that the factors one, I think we're in a collision state. I can't get my head around that. I don't know why it wouldn't be a factor of 3 or 10 or something like that. But if you could perhaps walk us through that one more time, I'd appreciate it. Thank you.
Okay.
All right. Seeing nothing else on that matter, we'll continue case number 23655 to the April 2024 meeting of the Oil Conservation Commission. And then moving on to the next item of the agenda, other business, potential rescheduling of the April 11th. That was due to a conflict on my schedule, but actually that conflict cleared up. So we will keep the April 11th, 2024 hearing as currently scheduled. And with that, announced our next meeting date, and I will adjourn this meeting of the Oil Conservation Commission. Thank you.
Thank you for your time.